Okay, we're on the record in the matter of the people of the state of Michigan versus Monay Thomas, file number 20-02275, council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Monay Thomas.
Okay, today's the date that was set for jury trial, scheduled for 8 o'clock this morning. Don't interrupt me, please. So scheduled at 8 o'clock in this morning. Are you just now getting here, ma'am?
I am. I had to wait for a babysitter to get my kids. I couldn't leave until then, ma'am.
Okay. Are we ready to proceed for trial on this?
Yes, Your Honor.
We have our witnesses here?
Yes.
Okay. The jury is on their way, or we're calling the jury already? You notified? Doesn't matter, we just need a jury.
I have to tell them which one.
Well, did you let them know that we needed a jury?
Oh, because she wasn't here.
Okay. We need a jury for Thomas. I was telling you to do one for Scott. But they could always switch it. It doesn't matter, as long as they get a jury. Okay. This is the 2020 case. We need to proceed with that one first. You have a seat. We'll go back on the record on your matter. On the record in the matter of the people of the state of Michigan versus Sheena Scott, file number 23-01015. Council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
Good morning, Honor. This is going to be after the defendant Sheena Scott. She is present approaching the
Okay, today was the date and the time that was set for a jury trial. However, there is a case with a priority number because it's from 2020. This is a 2023 case. So we're going to proceed on trial on that one, and this one will need to be reset. I think it was all supposed to be, no, we already took care of the PA53. We had witnesses here on this, correct?
Yes, Your Honor.
Okay, so this matter will be reset to the next available jury trial date.
Thank you, Your Honor.
No problem. August 28th at 8. August 28th work for you? August 28th.
Oh, August. I've got a conflict that day.
Oh.
2 conflicts that day.
Can do October 16th. October 16th.
That is fine, Your Honor.
Okay. Do we have another trial with an older number? Yeah. Okay, I don't want to put it on the number with an old number because then we'll have to reset them. November 13th?
November 13th.
Yeah, because if I put you on October 16th, there's one already set with the older number. and
Oh,
you'll
okay.
get
So
bumped.
we don't want to be in the same position, right? See, November 13th, you said?
Yes.
That's fine.
We set for that date and time. Any additional matters on the record for that file today?
Nothing from the people, Your Honor.
Nothing else, Your Honor. Thank you.
Thank you. You're all set. On the record in the matter of the people of the state of Michigan versus Matthew Fox, on number 23-01065. Council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
Does he have an attorney?
Your appearance, John. Oh, I'm sorry. Assistant Public Defender John Lee on behalf of Matthew Fox.
Okay, thank you. Today was the date set for a jury trial. Were we ready to proceed today? Do we have witnesses?
The people have witnesses here, Your Honor. However, after conversations with defense counsel, I believe this matter just recently was assigned to Mr. Lee, and so I'm not quite sure if he has discovery yet. I will let him speak to that matter.
Do you have discovery on this matter?
I do not yet.
Okay. When were you appointed on this?
We were appointed in June. We filed our appearance and requested discovery. However, as has sort of become customary, animal control cases, we don't usually get discovery until we've made several requests. So we have made another request. I have emailed Mr. Brodowitz. I anticipate discovery will be forthcoming, but we have not yet received it.
I have an appearance in our file from June 15th, 2 months ago. That's not recent. How is that reasonable? It's the day of trial and you all haven't provided him with discovery.
That I cannot speak to, Your Honor, as I am new to this file. However, I will get with our discovery department to get Mr. Lee the necessary discovery as soon as possible.
If you want to request an adjournment, that's fine. I'll entertain a motion to dismiss. They're not ready to proceed.
Your Honor, we would make a motion to dismiss as we have not yet received any discovery.
Motion to dismiss is granted. I need a nollie. That is without prejudice. I need a nollie. You can have a seat, sir.
Thank you.
On the record in the matter of the people of the state of Michigan versus David Lee Cheney, file number 23-01459. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant David Cheney, who is present and standing to my right.
Okay, today was the date set for a final pre-trial. Do we have witnesses here?
Yes, Your Honor.
Okay, and we're continuing to our trial on this, counsel?
Your Honor, at this time, there is no offer. I would, if there isn't going to be an offer, yes, I would continue it on to jury trial.
Today is the final pre-trial, so any offers or negotiation would have had taken place before today, I'm sure. This matter's been pending since May.
Yes, Mr. Cheney was in custody for a while. The only issue I feel like we is the question is on restitution, but other than that, Your Honor, there's no offer, so the choices is plea discharge or take it to jury trial, and I believe Mr. Cheney would take it to jury trial.
Mr. Cheney, are you awake? I can't hear you.
Yeah, trying to.
You're trying to? Or why are you not able to wake up?
I sleep early.
I'm sorry?
I ain't go to sleep early.
What time did you go to sleep?
3.
3 o'clock in the morning? Is that a yes?
Yeah.
Yes?
Yes.
Okay. And you knew you had court today?
Yeah.
So why were you up to 3 o'clock in the morning? Were you working?
No, I don't work till 2.
2 this afternoon? Yes?
Yes.
Okay. Well, you need to go to sleep if you're gonna have court, okay? How can you assist in your defense if you're half asleep? You get that? Okay. All right. The other matter is scheduled to go to trial on August 28th at 8 o'clock in the morning. You get a good night's rest before then, okay? Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing for defense, thank you.
You're all set, sir.
I think you're all set because you have everyone prepared for jury trial.
On the record in the matter of the people of the state of Michigan versus Trinity Hughes, file number 21-02022. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Trinity Hughes, who is present standing to my right.
Today was the date and the time set for a final pre-trial on an assault and battery. Do we have a witness here today?
Your Honor, I previously called both the hallway and the courtroom, and I was not made aware that any witness was present today.
Your
So
Honor,
the people will be unable to proceed at this time.
motion to dismiss without prejudice.
Your motion to dismiss without prejudice is granted. Without prejudice means that the people do have the right to reissue the charge against you within the statutory time frame if the necessary witness appears, okay? You have any questions? Go get your copy of your Nolly and just, or your dismissal in just a minute, okay?
Okay, thank you.
You're welcome. Who is this? Is that Lorenzen?
Yes, it's Reginald Baldwin. I have him briefly on from the Forensic Center for sentencing, so I'll get on there and see.
He's under forensic order or something?
He was found not guilty by reason of insanity by Berry County. So it's my understanding now, after talking to CFP, that he's gonna be there for a year, and he was there since December, so.
He was there since December.
Yeah,
When
I
did he take a
mean,
plea in this case?
we took it back in like October.
And he was stable and sane then?
Yes, he was competent and everything. It's, Berry County found him not guilty by reason of insanity.
Okay, we have a note here. In essence. You need to speak to?
Yes, I do.
Okay, do we have another matter that you are?
Your Honor, I do have Lisa Swain at 8 o'clock.
Okay, on the record in the matter of the people of the state of Michigan versus Lisa Lene Swain, file number 23-00043. Appearance, please.
Jeff Reynolds on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant, Lisa Swain, who is present standing to my right.
Okay, today was the date set for final pretrial on aggravated assault. Do we have witnesses here?
Yes, Your Honor, the people have witnesses here and are ready to proceed.
Continue to trial.
Yes, Your Honor, I believe there's no offer. At this time, the options are please discharge or go to jury trial, and I would, Ms. Swain, do you agree we'll go to jury trial?
So we'll proceed to jury trial. You're scheduled for a jury trial August 28th at 8 o'clock in the morning, Mr. Swain. I just told someone else they had a jury trial at the same date. Is that Hughes?
No, that was Mr. Cheney.
Mr. Cheney. Okay, Ms. Swain's number is older than Cheney, so she would have priority. Okay, so we expect to proceed at that time, okay? Do you have any questions? Any additional matters for the record?
Nothing for the record, Your Honor.
Okay, you're all set.
That was August 28th, I think.
August 28th at 8 o'clock in the morning. Care of all of those at the 8. Yes, sir.
If I may, I know you've already issued the dismissal without prejudice, but can we go back on the record just briefly on Mr. Fox?
Mr. Fox on the record.
Yes.
Is he still here? Okay, on the record in the matter of the people of the state of Michigan versus Matthew Fox. Counsel.
Yes, Your Honor. While I am aware that you have already, that the defense has made a motion to dismiss and you've already dismissed this without prejudice, I did check our system and I did see that we, as the reason Mr. Lee had never received discovery from the prosecutor's office is that the prosecutor's office never received his appearance. So I do anticipate.
Why is that?
That I could not speak, Your Honor, as to why we did not receive his appearance.
Mr. Lee, do you have evidence that appearance was properly filed with the prosecutor's office?
I have the notes in my system from our paralegal that indicate that the appearance was filed prior. And I believe I have a copy of that appearance.
And you all file or serve them electronically with those?
Yes.
Okay, so that's easily traceable. I need to know if it was sent, because if it wasn't sent, then I'm not signing the dismissal.
I would have to ask the paralegal to give me evidence of her actually having sent it. She would have that in her records or emails. And
Okay, and then since then, because we've had a pretrial, one-time pretrial, June 12th, which I believe your appearance came after that. After we set, so you all haven't communicated about this in preparation for trial?
my office, again, I don't know who put this in the system.
I'm not talking about your office. You're assigned to this case. You're assigned to this case, at least since June 15th for you, not so much for you, but we knew this was going to trial.
No, I did not. That's my point. our office had this in our system as a pretrial conference, which is why I emailed Addie earlier in the week to see if we could get it changed to a pretrial conference. So the first knowledge I had of Mr. Fox actually being scheduled for trial was when I started doing my docket preparations for this week. I did not know that we were facing trial.
Interesting. The email I have was that you said this is set for jury trial. You want it to be reclassified as a pretrial.
That's correct, because that's when I discovered it was set for a jury trial. I got the docket from our paralegals, I think on Wednesday of last week. And that's when I discovered that we were set for a jury trial. It was not in my system as a jury trial.
Okay. Well, I'm not gonna sign a dismissal then, because I feel like if you filed an appearance, at least in June, you didn't receive discovery, you probably should have looked for it a little bit more and not just expect they didn't give it to you. What is this one? Hughes? And I don't have enough evidence to believe that they received your appearance at this time. So we will continue to a pretrial. You need to make sure they get a copy of your appearance, and then he will ensure that you get discovery. I recognize the discovery comes from Ingham County Animal Control, but the prosecutor is responsible to make sure that the public defense office or the defense counsel gets it. You can't just leave it at the whims of the Ingham County Animal Control. They don't prosecute cases. Prosecutor's office does. So we'll set it for a pretrial. August 28th at 10. August 28th at 10.
Very well.
Okay, any additional matters, counsel?
Nothing from the people, Your Honor.
Nothing for the defense, Your Honor.
You're all set. Ms. Donnelly, is she already in the room with her client?
Yes.
Okay. Okay, who's representing Quintana? Is that Ms. Donnelly as well? Quintana?
Sure.
I'm just saying this here, you don't need to take those. Okay, on the record of the matter of the people of the state of Michigan versus Raquel Palacio, file number 19-00071. Ms. Palacio, can you hear me? You're muted.
I'm sorry. Yes.
Okay, Ms. Palacio, you owe $200 on a no ops.
Yes.
And you believe.
I'm sorry, Your Honor. I didn't hear you.
Believe you said you would pay that by July 24th, but I'm not sure I'm understanding the note here. Why haven't you made the payment?
Actually, Your Honor, I have been taking care of all my legal matters in every county, and I owe collections in every county. I just need some more time, please.
How much time do you need?
Could I have 30 days?
Okay, I'll note here you'll make payment no later than September 15th.
Thank you so much.
Thank you, you're all set.
Thank you. Have a good day.
Thank you.
Thank you.
We're on the record in the matter of the people of the state of Michigan versus Rodrigo Quintana. File number is 23-01122. Counsel appearance.
Your Honor, Assistant Public Defender Sarah Donnelly on behalf of the defendant Rodrigo Quintana, who is appearing separately by video.
Mr. Quintana, can you unmute, please? Can you hear us, Mr. Quintana?
You're muted, Rodrigo. There you go.
Okay, Today's the date and the time set for a sentencing. I do have a pre-sentence report and recommendation from the probation department. It's stated for July 31st. Did you get a copy of that, Ms. Donnelly?
I did, Your Honor, and I've had an opportunity to review it with Mr. Quintana, and we have no need for any additions, deletions, or corrections.
Oh, okay, very good. You can make allocution.
Thank you, Your Honor. In regards to the pre-sentencing report and the recommendation, we have no objections. Mr. Quintana is an excellent candidate for probation, being his first offense. He has already been granted a 7694A status, so the recommendations, I believe, are appropriate. So we would ask the court to follow the recommendations of a 12-month term of probation, in which Mr. Quintana will be completing the batterers intervention programming, outpatient treatment, and I believe that there was also a recommendation that he be put on a scram tether. We would note that he has been on a tether for several weeks now, and
Scram tether?
no, a GPS tether. And that, or no, did you put a scram tether? I can't. No, I think it's just a GPS tethers on him right now. And he hasn't had any issues since being released from jail. So we'd like the court to consider switching the GPS tether to a scram tether to monitor his sobriety. But other than that, Your Honor, the only other thing is I believe there was an agreement on restitution in this matter for the phone. It was about $400. The file, there is something in here about damage to the door that was done. It's my understanding that the damage to the door was fixed, and that like I said, the agreement was for $400 for the phone. You can correct me if I'm wrong, but
I was gonna address that. I actually was gonna say I need the prosecutor to come back in here on this because we have two restitution forms. One is for 5/19/35, and there was one that was already in the file for $400.
oh,
So there's two. Now I need clarification as to why there's two. And the one that's in the file was signed by APA Sage Castleman on June 12th. Can I have your appearance on the record, counsel?
Jeff Broderick on behalf of the people you're on.
Okay, Mr. Broderick, I need you to do some investigation on the sentencing matter for Quintana, because I have two restitution forms. One is for $400. That was completed the date that the plea was accepted by APA Sage Castleman. However, the probation department also has one in here for 5/19/35, and I don't know why there's two separate orders of restitution or request for restitution.
What was the first one, sir?
I have one for $400 that was submitted by your office at the time of the plea. But there's another one in the file for 5/19/35. I'll allow you to investigate that. Let's see. Wow, I see. Is Helena Raza here? Okay, did you want to make a statement, ma'am?
Yeah,
I'm sorry?
I'm very nervous though at the same time.
Oh, you don't need to be nervous. You can take your time, okay? Okay. Do you know what the 5/19/35 is?
That may be with the door. I do want to state that the first door that he busted was when our daughter was 2 weeks old. That was fixed. However, the big night where the cops were called, the door was busted again.
This 5/19/35 was from the incident that we're here for today?
I think so. I think that should be with the cost of the door and the phone that I had to buy outright.
So that's the $400 plus the door, is that what you're saying?
I think so, yes.
Okay,
And then,
and how did the door get busted?
more than likely he hit it again. I have a picture of that. It's not as bad as the first time he busted the door, but.
Okay, you can give your statement at this time.
Okay, do I stay
You
here?
can, if you feel comfortable there, that's fine, or you can come up here. We just need you to be closer to a mic,
Okay,
or you gotta speak loud.
I have a very long statement. I don't know if that's
Yeah, I can hear it.
acceptable. However, I do want to add something, if that's okay.
Say, it's your time to speak.
Okay, I noticed that he is wearing my bracelet and our promise rings, which is very weird to me because he cheated on me throughout the whole relationship. And I don't think that you do this stuff to someone you love. So I find that that is probably one of the games that he's playing right now. And I just wanted to point that out. But so, okay, this isn't just about me. This is also about my kids. I'm not the only one that night or during the relationship that was abused, threatened, or put in harm's way. I'm sorry.
Take your time.
At the beginning of the relationship, Rodrigo was trying to attempt to stop using substances for me. Obviously, that did not work out so well, and I did get pregnant too fast. He would be out for multiple days at a time, completely ignoring me and cheating, making it to a point where I could not get a hold of him while I was very ill from the pregnancy. So it would cause fights when he got back. I would tell him to leave because I knew I deserved better, and he would never leave. Eventually, everything progressed to him holding tests for me and set me up for failure, gaslighting me, holding me down, and once being thrown on the bed even while pregnant with his child. During this time, I was not able to work from the medical condition, and I needed help to take care of my firstborn, who was 2 years old. I eventually learned that he did not have the patience to take care of kids, and a lot of our arguments were also caused by how he treated my son. Being that it was hard for me to take care of my son, Rodrigo locked my firstborn in his room all the time because he didn't want to take the time to help him pick up the toys from the living room. He would get angry if he stepped on a toy or if it was in the way and threatened to throw it out. I would get up and let my son Xavier out and explain to Rodrigo that he's just 2 years old and that he shouldn't be in the room all the time and that this is his home too. Rodrigo would also force Xavier to eat his food. It got to the point where he took a bungee cord and wrapped it around his chair to make him eat all the food he was given. It irritated Rodrigo that my son sucked his thumb and wouldn't let Xavier near the child we share, who is my second born, because he didn't want his germs to spread to her. At night, Xavier would play with his nightlight and Rodrigo would take it away, making him sleep in the dark. So during some of the arguments and abuse, Xavier would be in his room across the hall in total darkness, hearing Rodrigo and I argue, while he would also hold me down. Due to this, my child has night terrors every night. He has also threatened Xavier before during a drive home in the night. Xavier kept dropping his toy and I kept picking it up. It was a 2-hour drive and it was dark. Xavier was 2 at the time and of course antsy. I ended up unbuckling to pick up the toy and Rodrigo yelled at me, telling me not to. And if we got into a car accident and I got thrown out the front while pregnant with his daughter, he would rip his effing throat out. So his actions from all these towards my child seemed abusive to me, and I would put my foot down with him to not treat my child that way, which then turned into an argument, and even sometimes happened in front of Xavier and Leilani. I would tell him I don't want to argue in front of the children because I don't want to impact their mentality negatively. He would respond by making a sarcastic comment, dismissing my concerns for my children's growth and well-being. Most of the abuse was towards my son and me, but also impacted Leilani while I was pregnant with her. After she was born, he would sometimes scream at her because she would not stop crying and bust a door open with her in his hands while she was 2 weeks old. All this kind of escalated into what happened on April 8th. I stood up for my son and it progressed into violent physical abuse towards me, and while Leilani was feeding from me or while in my hands trying to soothe her. Rodrigo also threatened Xavier that night, stating he would drop a pillow on his head while he was sleeping. This was the night I feared for my children's life and my own. After he fell asleep, the only way I could reach out for help was through my laptop because he busted my phone and ripped me back into the apartment while running out for help while Leilani was in my hands. While living through all that, I became very depressed and miserable. Now it feels like my life got completely flipped upside down, and it got worse before it started to get even the tiniest bit better. I find it funny
how I find my way out of the abuse and I'm still going through hell. Excuse my language, sorry guys. I would feel like I was trying to keep myself from drowning and my children are on my back, trying to make sure that they stay afloat. I ended up moving because I no longer felt safe being there since he lived right across the street when he moved back into his parents. Between having to juggle an emergency move, custody, child support, DHS, legal aid, care, Eve, this court case, and whatever else all that came with this, I still had to maintain my full-time job and still be a mother to 2 children. I lost a lot of time for work because of having to maintain everything I was juggling. For my job, no matter what, we must work 40 hours a week. So I had to make those times back that I missed, causing me to miss more time at home to take care of my children or get things done at home I needed to get done. My work also requires hitting daily and monthly goals. The time I had to take from all this severely impacted those. Thankfully, my management team is understanding with my situation, but it still does not mean I'm given a free pass. I am also on a 2-hour schedule for pumping, which now I have to give up because I'm over that now. It's too much stress. For my infant to provide her food, having to go into court and other places I needed to be to handle this case. I missed those pumping schedules and it caused lack of supply, as well as the stress from all this immensely dwindled my supply. To add to the lack of sleep I got from Xavier's night terrors and helped in lowering the amount of milk I produce. I went from making 5 ounces more than what she ate to making 8 ounces less. I will soon have to supplement with formula now, and this was 7-Eleven when I made that, and now I am supplementing. When before I had 3 rows of milk stored in the freezer, and now I only have about 10 baggies. Now I only have 2. Now with not making what she needs, I need to work even harder and pump more during the day when I still have 2 kids to take care of after work. Pumping is very hard work and straining. I am devastated. I am hurt. I am pissed off. It breaks my heart that I'm not making what she needs anymore. This is all because of the aftermath from juggling everything involving the DV case. I bawl my eyes out quite a bit because of losing the supply I had for her. I also have been suffering with suicidal thoughts. I would never do anything to leave my children, though the turmoil from this has severely impacted my mental state of mind to where it comes across every now and then. I also suffer panic attacks and suicidal thoughts during the relationship. With everything in general, I was crying every day in the car on the way to and from work. Even at work sometimes, it has made it harder to tolerate and help patients on the line who are argumentative. I have had a total of 5 meltdowns at work and 2 panic attacks where I have hyperventilated and had to clock out, making me miss more work, and now more since I've made the statement. Also, the lack of sleep from Xavier's night terrors helped contribute to more stressful emotions with my day-to-day life. We have PTO at this job, but I did not have any PTO from just getting back from maternity leave. So the little PTO I had was used up already. It didn't help when the case kept getting adjourned because of him breaking the no contact order. Why did I have to go through more time and troubles all because he couldn't stop breaking the no contact order? Why did my children and I have to keep suffering from losing more time because of his actions? Everything I was juggling started to slow down around the time he finally pled guilty. So by then I was finally able to be there for my extremely traumatized son. He has regressed in his mental growth immensely because of this. It's finally been 3 months and now I can finally get him into therapy when his mental health should have been first, but I couldn't take care of that right away because of the amount of time this case ate up from being adjourned multiple times, as well as not having the time to get myself into therapy, who specializes in helping victims of DV. With how this case has impacted my children and I, there are a couple things I would like to see. I want justice for my son, for the child abuse, and I think that serving more jail time would fulfill that. Along with the probation and substance abuse programs, I feel 22 days served is not enough for the abuse and trauma he inflicted onto a 2-year-old, now 3-year-old, as well as committing violence towards me while his own daughter was growing inside of me. I want a sincere apology from Rodrigo for everything he has done and how it has affected my children and me. I would also like to see an apology from his family, if that's okay, for enabling his behavior and treating me with animosity during it all. It would be a nice start for Leilani's sake, being that she was victimized too and was attached to me inside and out during the abuse. And that's it.
Thank you for that.
Thank you.
And you're stronger than you think.
Thank
Okay?
you.
Okay,
I
and
am.
your children need you to be strong. Okay, so continue to seek your healing so that you can be the best mom and support system for them, okay?
Thank you.
Okay, I do want to address one thing that you stated about the case being adjourned. This case was never adjourned.
I thought with like the, how it kept going on with the no contact order and it kept going.
The incident happened on August 9th. His first pretrial was August 24th. At that time, discovery was still pending, so his attorney had not yet had the information they needed to proceed with the case. So it was set then for a final pretrial, which
Okay,
is typical. It's not an adjournment. Set it for a final pretrial to make sure we have a witness or a victim, or we're ready to proceed with the case. You appeared, that's the final pretrial would be the first time we would have subpoenaed you to appear.
okay,
You appeared at the final pretrial. He pled guilty at the date of the final pretrial.
okay,
And then today's the next court date we have. So this case was never adjourned.
okay. I didn't
Okay.
understand how I need.
Okay, so and then as it relates to the violation, I only got notified once that he violated or allegedly violated, because I don't think we ever had a hearing on that. And I remanded him immediately
Yeah,
for GPS tether. And then I never got any more notice. I get that when, if someone violates, the only way I know is if the police is called.
Okay, yeah, I did call the.
Again, I only got one violation. There was a GPS tether added with victim notification for your protection. And it does not, we've not gotten any violation. The GPS tether has not notified us that there's been any violation of that.
Yeah, it was after the GPS tether, he still messaged me and the Shiawassee County should have.
Okay, so that's another county that would have that information.
Yeah,
We don't have that
because I moved
information.
far
Okay.
away.
Okay, sounds good. So, so you're saying Shiawassee County, there's another case pending? Or is that where you notified?
That's when I notified that he messaged me again.
Okay, but he doesn't have anything pending. in
Your Honor, there
Shiawassee.
were 3 PA-53s on this, the Shiawassee one being one. He pled guilty to the PA-53 when he pled guilty to the domestic violence, to one of them. We have dealt with these violations.
Okay,
There was at first you remanded him for a GPS
yeah, there
tether.
was two violations on the same day as the April 24th that we dealt with. I revoked his bond on May 22nd. And then he pled guilty to the violations and to the domestic violence at the date of the final pretrial. He did have custody 22 days credit time. That was a sentence for the 22 days was sentencing for the violation, not for the underlying case, okay? So I'm gonna sentence him now. There was a killable of no upfront jail, just for your information. Killable means that he had an agreement with the prosecutor's office that he would not be sentenced to upfront jail if he pled guilty to the original charge. I have not decided yet whether or not I was gonna sentence him to jail. And if I was going to sentence him to jail, then I have to notify him of that by law and give him the opportunity now to withdraw his plea and then proceed to trial, which could further tie up your life and further contribute to any stresses that you're doing if we have to run a trial, because it wouldn't be today. You understand that?
I just want justice for my kids.
And he's pled guilty to the charge, so justice will be executed one way or the other. But jail's not always the way to get justice. Sometimes jail is just punitive. But if you want justice for your kids, then what you want is rehabilitation, because he's the father of one of those children, correct? So you want him healthy, because that child still needs a father.
I want whatever God thinks is rightful. That's all I
Agreed.
want.
Agreed. So what you don't want is someone for him to be continued unhealthy and not be able to have a meaningful, fulfilling, healthy relationship with his child. And I don't know if there's something pending with the family court as it relates to custody and for his ability to spend time with the child, but he has the right to seek that. And what you want is if he seeks custody or seeks visitation, that he's healthy enough to do that and have a meaningful relationship. And sometimes jail is not suited for that, okay? So these are all the things that the court has to consider when we're issuing sentences. But your statement was impactful, it was powerful. I think it's liberating for you as well, because you got to get a lot of things off your chest, so that both the court can hear it, but also he heard it, okay? So I applaud you for that, okay, ma'am? Thank you. Okay, counsel, any further allocution, and did we find out any more information about the restitution?
Yes, Your Honor, it appears there were two receipts submitted to the prosecutor's office for potential restitution. One of those being a total of $423.99, and one for a total of $95.36. When added together, those total, I believe, the amount that the probation came up with, which was $519.35.
Okay,
So I believe that is where the probation department got their number from.
sounds good. Okay, any further allocution?
Yes, just briefly, Your Honor, in regards to the restitution, it was my understanding when we agreed and pled guilty at the final pretrial that that it was for a previous incident on the door. And now with it being, today being presented, it was all in the same incident that evening in which Mr. Rodrigo Quintana was charged. I just leave it to Mr. Quintana. When we discussed it, it was only for the phone, but Mr. Quintana, you heard today that it was, the door is being asked for because there was damage done to the door that night. Are you okay with paying for that door, or would you like to have a restitution hearing on it?
I don't recall me damaging a door that night, but if I have to pay it, I'll pay for it. It's not a problem for me.
All right, Your Honor, then I'll be no further. I just asked that the court follow the recommendations. Thank you.
Okay, I've had an opportunity to review the pre-sentence report and recommendation for probation. Mr. Quintana does not have a prior criminal record. This is the only record. My records reflect that the prosecution did object to sentencing under 769.4A. So that will not be granted. So you don't get the benefit of any special status. This will be a public record for you, okay?
Yes, ma'am.
Okay, and the recommendation here is that you scored high needs in the family, IP relationships, and companion domains. You had a moderately high score in personality characteristics and substance use domains. And lastly, you scored moderately low in employment and leisure activities and responsivity domains. I do see that you are employed full-time at Trinity Hughes. And so that's why that was moderately low for your scoring in that category. But those other categories need some work. First, prioritizing, I would say, substance abuse and use, and then relationships and companion domain, because if you have a substance abuse issue, it's likely that you're not able to even properly address meaningfully the relationship issues. So we need to get that addressed. Based on your prior criminal history, which is none, this is your first offense, you're gainfully employed, you have children that you need to be supporting financially at minimum, you sitting in jail is not in the best interest of justice. What we need to do is address the issues that cause you to find yourself before the court in a domestic violence situation. And so the court will adopt the recommendation of probation. You will be sentenced to 12 months reporting probation. While on probation, you have the following conditions. You're not to have contact with the victim unless a family court orders that you can have contact with them for the purposes of childcare. I don't make arrangements as it relates to childcare. We deal with criminal issues here. And so as it relates to her being a victim in a criminal action, there's going to be a no contact order continued. He cannot have contact directly or indirectly
I understand, Your Honor.
with Raza. Do you understand that?
Yes, ma'am.
Do you understand that indirect means you can't send a text message? You understand that? You
Yes, ma'am.
can't slide in her DMs. You can't write her a letter. You cannot text her. You can't send messages through Morse code. You can't smoke signal her. You can't use a paper cup telephone mechanism. You understand that?
Yes, I understand that, Your Honor.
Okay. And then you're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind while on probation. You're not to engage in any assaultive, threatening behavior. You're not to use, purchase, or possess alcohol, marijuana, or controlled substances you do not have a valid prescription for. I'm ordering you to submit to random preliminary breath testing and/or urinalysis testing. You will get or be placed on a scram tether. And so we'll be testing you, you'll be tested daily via scram tether for the use of substances. You're not to be at any bars or nightclubs while on probation. You're responsible for the fee for PBTs and/or urinalysis and/or scram tether. I'm not going to order you to test or drop while you're on scram tether because that's duplicative. But you are responsible for the cost of the scram tether while you're under monitoring for scram tether. Do you have any questions about that at this time?
No, I don't, Your Honor.
I'm going to order you to participate in outpatient treatment program and parenting classes at Crystal Ray. Need to maintain your employment while on probation and provide verification of that to the probation department. But also order you to complete the Batterers Intervention Program. Do you have any questions about the conditions of probation at this time?
I do not, Your Honor.
Okay, so long as you do not violate any of those, the 93 days Ingham County Jail that I'm ordering will be suspended, okay?
Okay, Your Honor.
As to fines and costs, it's a $75 crime victim rights fee that you're responsible for, plus a $50 state minimum cost that you will be responsible for. There's a $30 per month oversight fee for being on probation that you are responsible for. And I'm also ordering restitution to be paid to Helena Raza in the amount of $519.35.
Okay.
It's a total of $1,004.35. You'll make monthly payments on that, okay?
Okay, Your Honor.
Do you have any questions about your fines and costs? Okay, lastly, there's an advice of rights as to probation. It says you have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs, except for domestic violence, criminal sex crimes, and stalking offenses, or an offense where the defense was of guilty but mentally ill was asserted. You may be eligible for early discharge from probation. You would have the right to request early discharge from probation once you completed half the original term ordered by the judge. Your probation officer may, but is not required to, filing notice with the judge once you become eligible for early discharge. The probation officer must send to you and the prosecuting attorney a copy of the notice. The prosecuting attorney has 14 days from receipt of that notice to object to early discharge. You may make your own request for early discharge from probation after meeting the following conditions. First, you have completed all of the required programming and you have not violated probation within 3 months prior to your request. You would send a copy of your request to the probation department and to the prosecutor's office. Prosecutor would have 14 days to object to your request for early discharge. If a hearing was scheduled to address an early discharge from probation, you would have the right to hire an attorney, but you don't have the right to court-appointed counsel for any such request. And a request for early discharge can be made by completing the early discharge from probation form, and that's the MC 512 form. That form is available on the court's website. However, you are on probation for domestic violence, so you would not be eligible to make such a request, okay?
Okay, Your Honor.
Do you have any questions?
I do not.
Okay, any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing for defense, thank you.
Okay, Mr. Quintana, I need you to check in with our probation department within the next 48 hours, and they will prepare the order of my judgment of sentence for you to review and sign, okay?
Yes, Your Honor.
Okay, you're all set. Thank you. Thank you. Okay. Okay, you can be seated. Okay, we're on the record in the matter of the people of the state of Michigan versus Reginald Baldwin. File number 22-02595, counsel appearance.
Jeff Rodos on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Reginald Baldwin, who is appearing separately by video.
Okay, Mr. Baldwin, can you hear us?
Yes, I can.
Very good. Today's date and the time that was set for sentencing. I do have a pre-sentence report and recommendation from probation, fines and costs. Any reason to make corrections, updates, or deletions?
Your Honor, I do believe that there was a request for restitution, which we don't have any objections to either.
Okay, thank you. Any further allocution that is at this time?
No, Your Honor, just that Mr. Baldwin will be at the Center for Forensics for the foreseeable future. I believe he was ordered there, or he is expected to be there a year.
Okay. Okay, so Mr. Baldwin, due to the fact that you are under or in the custody of the Center for Forensic Psychiatry being treated, as well as already under supervision by the 55th District Court, it's not meaningful for this court to put you under any further supervision or court sentencing to a jail time. There is a large amount of restitution, however, in this matter. Ironically, this form was completed by Mr. Brian Ring. And so the amount being $1,506.02 in restitution will be ordered. to the victims, motor cars of Lansing. $75 crime victim rights fee and $50 state minimum cost. I'll waive discretionary fines and costs because it's not meaningful. At this point, let's see, plus 125. And your total amount of fines and costs and restitution is $1,631.02. And you can make a payment arrangements once you are at a healthy state and back into the community. Okay, sir? Mr. Baldwin? I don't know if he can hear us. Mr. Baldwin, can you hear us?
Yeah, I can hear you fine.
Okay, do you have any questions about your fines and costs?
No, I do not.
Okay, any additional matters for the record?
No, Your Honor, thank you.
You're all set, Mr. Baldwin.
Thank you.
You're welcome.
Thank you.
Thank you.
Thank you.
Thank you.
No, it was a Baldwin.
Yeah.
Restitution.
How long is he on probation? 6 months?
He was, 6 months back in July of last year. I don't know exactly what's. I think he might still be on probation. You got to send a CFP.
Oh, yeah, I did say in this report, his expected end date was supposed to be May 15th. So he should be done, but who knows?
What was the restitution amount on that?
$1,506.02.
Thank you.
Who's on Joy's iPhone? And who's on the regular iPhone? You all need to update your devices so I know what your names are.
Michelle Van Brunen.
But I'm ready on Javon Shaw and Sylvia Montano.
Okay, Sylvia Montano.
Yes.
Okay, we're on the record in the matter of the people of the state of Michigan versus Sylvia Montano. I have file numbers 23-01675, 23-02128, 23-02129, council appearances.
Jeff Rodos on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Sylvia Montano, who is appearing separately by video.
Today's the date and the time that was set for pre-trial on 2 dog at large and 1 dog bite. How are we proceeding, counsel?
Yes, Your Honor. At this time, defense has provided me compliance with dog at large, so the people would be seeking to dismiss the 2 dog at large cases for compliance. However, with the dog bite, I believe negotiations are continuing, so I would leave it to that.
And also, I am missing discovery on the dog bite, so we're just gonna have that briefly reset so that I can get that and any offers.
Revocation your date,
August 28th at 9:30.
August 28th at 9:30. Any additional matters for the record today?
Nothing from the people, Your Honor.
And no for defense, thank you.
Thank you. You're all set, Ms. Montano.
Thank you. Have a good day.
Same to you. On the record in the matter of the people of the state of Michigan versus Javon Anthony Shaw, file numbers 22-01243 and 22-02100. Council appearance.
Jeff Rodos on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Javon Shaw, who is appearing separately by video.
Okay, today was the date and the time that was set for pre-trial. We were here previously, the defendant was referred to competency in a matter before Eaton County. How are we proceeding?
And in Mason, Your Honor, two matters. And I believe we're still waiting for that competency review or the report.
So we need to reset these.
Yes, Your Honor.
I'll give us, well, at least 30 days.
September 18th at 9:30.
September 18th at 9:30. Mr. Shaw, can you hear us?
He unmute himself.
I think you did earlier. There you go.
Oh, there you go.
Yeah,
Did
I
you
can
hear
hear
us?
you. Yes,
Okay, we're resetting your matter to September 18th at 9:30, okay?
September 18th.
That's correct.
Okay.
I'll let you know, Javon. I'll let Joey know.
Okay.
You're all set unless you have questions for the court, okay, sir?
Okay.
Thank you.
All right.
You need to speak to
Yes,
Van
Michelle.
Drunen, and let's see. Jamie Jared. Who's representing Jamie Jared?
I am representing Jamie Jerry.
Is Jamie Jared here?
I have not seen this Jerry. No.
Okay, well, it should be sworn. Who's representing Juana May?
I am, Your Honor.
Is Juana May here?
Yes, she is.
Okay. On the record, in the matter of the people of the state of Michigan versus Juana May, file number 23-02204. Council appearance.
Jeff Reynolds on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Juana May.
Okay, today is the date and the time that is set for a pretrial on one count of domestic violence. How are we proceeding?
Yes, Your Honor, at this time, the people have made an offer for the defendant to plead to count of domestic violence with 769 if eligible. With that, I would leave it to the defense.
Your Honor, the defense is declining that offer and would like to set the matter for a final pretrial and trial.
Final trial October 16th at 8.
October 16th at 8 o'clock in the morning in person at the court is the final pretrial, okay?
Jury trial November 6th.
November 6th at 8 a.m. is gonna be the jury trial. Usually we're scheduling November. I'm gonna be able to go hunting. Any questions? Any additional matter for the record?
Nothing from the people, Your Honor.
Get you a copy of your notice to appear, okay? Thank you. Okay, let's see, I think that was Amber Valencia is represented by Carter.
Yes, he was, he's outside.
Is Valencia here?
No, Mr. Carter is, but not.
Yeah,
Okay,
he's
well,
outside
tell
the fence.
him we can make sure his client, he can be on his way.
Stick around for a few minutes when she shows up.
That's what I'm saying, Amber Valencia is, we see her often, don't we? Okay, Jabari Sapp. Jabari Sapp here? No. Oh.
I heard he went there first, they sent me there with it. Needed to turn it into somebody.
Wait, what is this? How much is he? Oh, $50. So, Sapp. $2017.
Oh, no.
No? Oh, okay.
Just over 1,000 on that.
Wow. Andrew Navarre's not here and neither. That's the only one at 10. That's not here. Hi, Mr. Carter.
Hi.
Have you spoken to your client at all? No.
No, I couldn't get a phone number. I sent her a police report on first and asked her to contact me.
Okay.
And
Sounds
I haven't
good.
heard anything back.
Sounds good. I'm gonna issue a bench warrant. If she shows up today, though, we'll
Yeah.
reset it.
Thank you. I'm gonna hang out just in case she does because she may be hanging.
Sounds good.
Yeah.
Mm. No, 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 no.
Okay, on the record in the matter, the people of the state of Michigan versus Michelle Van Runnen. File number is 23-02181, council appearance.
Jeff Prados on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant, Michelle Van Runnen, who is appearing by video.
Okay, today was the date and the time that was set for a pretrial on a domestic violence. How are we proceeding?
Yes, Your Honor. At this time, there is an offer, though that may change. So I would leave it to the defense with that.
Set it for final pre-trial and jury trial, Your Honor.
October 16th for the final trial. November 6th for the jury trial.
Okay, Ms. Van Runnen, you need to appear in person October 16th at 8 o'clock in the morning for your final pretrial. And then if we proceed to jury trial, it's scheduled for November 6th at 8 o'clock in the morning, okay? You're muted, so I need you to unmute. You're still muted.
Sorry about that. Yes, Your Honor.
Okay, do you have any questions at this time, ma'am?
Not at this time.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing for defense, thank you.
You're all set, ma'am.
Thank you. Have a good
You're
day.
welcome. Same to you.
Your Honor, I may have missed. You've been for it, Mr. Navarre?
I have not called the case.
Okay.
I was gonna ask that we not, because I know that he appeared, I don't have good contact information for him, but he appeared last week by video, and I believe it might have been from Bear River. He is on
Yeah, it says
probation.
he has a parole hold and he is supposed to go to Bear River was mine.
Okay.
Yeah, he's a parole hold, so I was
I
gonna
just-
see if I could get, if he's not, I thought he was gonna appear because he appeared last week, but not just,
And just, no, not that I was requesting, I just remember you mentioned the name, Your Honor, so I wanted to make sure I didn't miss something.
Oh, no, I didn't. I just was making, I didn't call the case because the attorney wasn't in here yet. I'll reset it so you can look into that.
August 28th at 10 a.m.
then I didn't see Ramona Hunter. She's in Mecosta County. I thought we adjourned to have her written.
Oh, so she's not on my document anymore. We must have been adjourned already.
Oh, we had to, more time, okay.
Oh, I did. And then my computer was not, and my office wasn't letting me upload. So much going on.
I don't know. Do you know when Ramona Hunter was, when you reset it to? I'll look it up.
I gotta go get the jury instructions because it wouldn't let me. Oh, Zimmer is here. Who's representing Zimmer?
I am, Your Honor.
Yeah, my computer wouldn't start my Outlook in there.
She's on video.
You need to speak to me.
Yes, I do, because her number wasn't working when I called her, so I wanted to make sure. Also, Your Honor, last week when Marion DeWindy Moore didn't show up for sentencing, you said that if he got in contact with me, you'd rescind the warrant. I got an email from him. I'm gonna call him just to make sure, but if it's all right, can we pull the file today for me and that?
Well, based on an email?
No, like I said, I was gonna call him. He has a phone number, so I'm gonna go call him.
Oh, okay, sounds good.
Yeah.
Diana Zimmer? Hello?
Hello?
Yes, can you hear me?
Hello?
Can you hear me?
This is Zimmer. I'm letting her use my tablet. Yeah, I can hear. Can you hear me?
I can hear you. Where's Miss
This is
Zimmer?
Diana Zimmer.
Okay, where is she?
Diana Zimmer. I'm about to get her right now. Not stay. Here she goes. Can you hear us now?
I can hear you.
Okay. You might want to sit down.
She was in person last time.
Yeah, because they don't know how to
Don't
use
touch nothing. Don't touch nothing.
Oh, there she's in my breakout room. All right, I will.
She's not in the breakout room, is she?
No, she.
Oh, okay.
Yeah, I'll
She is now.
Yep.
Okay, Mr. Samuel is here. I need to go see if I can get these instructions real quickly. If not, I gotta call you.
Said nobody I know this time. So it's,
Where is the prosecutor? Mr. Samuel. Who's on the iPhone with the blue shirt?
It's Antonio Bryant.
Mr. Samuels, are you there?
I am, Your Honor.
Okay, very good. On the record, in the matter of the people of the state of Michigan versus Antonio Jaquan Bryant, file number 23-01393, council appearance.
thank you, Your Honor. Jeff Redowitz on behalf of the people.
Matthew Samuels on behalf of Antonio Bryant. We're both present via Zoom.
Okay, today's the date and the time. Ms. Zimmer, Ms. Zimmer, Ms. Zimmer, can you hear me? Ms. Zimmer, can you hear me? I don't think she can hear me.
I hope you don't run nobody over.
You see him come through real
I'm
fast.
gonna resend her to come in person.
Okay.
Okay, today's the date and time that was set for a pre-trial. I have an attempted police officer assault, resist, obstructing a weapons possession. How are we proceeding?
Yes, Your Honor, at this time, I have not had a chance to speak directly with Mr. Samuel, but I would like to put an offer on the record, and that would be for the defendant to plead to count 1. And with that, the people would dismiss count 2. And with that, I would leave the defense.
I would like some time. This is the first I'm hearing of that offer. I have tried to reach out to the prosecutor prior to this, have not gotten any answer. I would like to have a conversation with the prosecutor about this case prior to proceeding.
Okay. So we can reset this matter. I'm about to start a jury trial, so won't be having any discussions in the minute right now because you all can do that on other time, and I'll just reset this matter. That'll also give you time to discuss it with your client, and he can consider the offer. August 28th at 10:30.
I will be out of town during that time, Your Honor. I would like,
Let me reset it.
Can we make it on the 11th?
September 11th at 9.
September 11th at 9.
Thank you very much. 9:30?
Yes, sir.
Thank you.
Any additional matters for the record today?
Nothing from the people, Your Honor.
Okay,
No,
thank you,
nothing
Mr.
further, Your
Samuels
Honor.
and Mr. Bryant. Thank you.
Thank you.
Alrighty, thank you.
You're welcome. Who's representing Mr. Daffin? Oh, I don't know where she went. Who's representing Mr. Mick?
Also believe that's Miss Donnelly.
Oh, we need Miss Donnelly to be present. Miss Donnelly, you're doing Mick and Daffin?
I am. I'm ready on both.
On the record in the matter of the people of the state of Michigan versus Marshawn Daffin, file number 22-02636, council appearance.
Jeff Rodos on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant who is appearing separately by video.
Okay, today's the date and the time that's set for a pre-trial on a larceny. How are we proceeding?
Yes, Your Honor. At this time, I believe the prosecution and defense would ask for a brief reset of this matter. Mr. Daffin was originally referred to the diversion program through the prosecutor's office. He failed to appear for the initial diversion intake. However, after discussions with defense, I would like an opportunity to see if Mr. Daffin would be reaccepted into diversion. I believe the defense is on board with that plan. I would leave that to defense, Your Honor.
How much time are you looking for?
Just 2 weeks, I think, Your Honor, should do it.
Are you objecting to that, Ms.
Nope.
Donnelly? August 28th at 10:30. Do you have any questions today, Mr. Daffin?
No, ma'am.
Okay, well then we'll see you then, okay?
Okay.
You're welcome. Let's see, we're on the record in the matter of the people of the state of Michigan versus Andrew Mick, file number is 23-02231, council appearance.
Jeff Rodos on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant who is appearing separately by video.
Okay, Mr. Mick, we're here today for a pre-trial on a assault and battery. Was there an offer on this?
There's no offer at this time, Your Honor.
So yes, Your Honor, we'd be asking for final pre-trial.
October 16th at 8. Trial.
Okay, Mr. Mick, your final pre-trial will be October 16th at 8 o'clock in the morning in person at the court, okay? You're muted.
Oh, yeah, I was. Sorry about that, ma'am.
Okay, did you get that date for your final pre-trial?
You said October 16th, 8 a.m.?
8 a.m. in person.
All right, sounds good.
Okay, and if we proceed to trial, it's currently scheduled for November 6th at 8 a.m., okay?
Okay.
Do you have any questions for the court?
No, ma'am.
Okay, well, then you're all set for today. Thank you.
Yep.
Okay, I am going to do all the 130 arraignments of violations. We can reset the hearings.
Do we have a date for this Zimmer's reset, Your Honor?
October 28th at 10:30.
Oh, fun. You said the 28th?
Yeah.
In August?
Yes.
Okay.
Yeah, she said October. I think.
Yeah.
I know, I thought I said in October too.
That's what I.
Okay, and that's in person.
Yeah.
Then I've sent you the procedural and the instructions before trial. If you can review them, please.
No, she's in McCostick.
Oh, that's right, yeah.
And they adjourned, because
Yeah,
probably because we need
adjourned.
more time for the
What was
writ.
the?
I don't know, we'll just have to look online. Oh, okay, thanks.
Time is it? Addie,
Yeah,
what time was that?
10:30.
Okay.
Tell us if the jury is here.
Nick too, Bonnie. Nick to Bonnie. Bonnie, just check it.
Sounds good. Can you hear me, ma'am? Can you hear me? Can't hear on our device.
Yeah.
You can hear me?
Can you hear me?
Yes, I
Yes,
can hear
I
you
can hear
now.
you.
I called you several times previously and you could not hear me, so we removed you and reset you for in person. But if you can hear us now, we can proceed. Can you hear me?
Okay. Yes, I can hear you.
Okay. Can I have Zimmer files back, please? On the record in the matters of the people of the state of Michigan versus Diana Zimmer, file numbers 23-01-816-1718 and 01979 and 01980. Council appearance.
Your products on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Diana Zimmer, who is appearing separately by video.
Okay, Miss Zimmer, today was the date that was set for pre-trials. I have a dog, a vicious dog, a dog at large, another dog at large, another dog at large, and another vicious dog. Council, how are we proceeding?
Yes, Your Honor. At this time, after conversations with the defense, I believe we would ask that this be set for a second pretrial in order for Ms. Zimmer to provide proof of compliance for the dog at large and to look into any sort of possible restitution or anything for the vicious dog, Your Honor.
Okay, this is already reset, so we'll just keep that date.
Yes, Your Honor. Yes, I just got discovery, so we reviewed the facts, so now we're gonna be moving forward from that. I do believe that efforts have been made to make sure the dog doesn't get at large anymore, so we should be able to resolve that next time.
Sounds good. What date did we reset that to?
August 28th
already?
10:30.
August 28th at 10:30 in person.
Thank you.
Thank you. Do you have any questions today, ma'am?
No.
Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Nothing for defense, thank you.
Okay, you're all set for today, Ms. Zimmer.
Thank you very much.
You're welcome.
Do you want me, you want me to? Actually. Okay, so, yeah, I'll just- I'll check in, see if it goes to, same thing. Yeah.
Yeah.
Yeah. But she.
That's right.
Oh, you know. No, I use my card because I order it. in that place. Yeah, it's okay. Yeah, I'll go. You got my,
You know, here.
so you wanna change out? Or-
I said, well, I can give you one.
Oh, you don't want, I don't want yours because mine's more posted, so. Yeah. Yeah, see, there was a line separating. I should have a new battery. No, I'm supposed to be. In the battery. Do you need anyone call? Let me look at the doc. Yeah, you got your own. Drop Michael Johnson. Yeah, he's gonna be here. Well, those are gonna be, yeah. So I'll just, Michael Johnson. I'll call them.
I'm gonna do the arraignments.
Yeah, the arraignment, Drew Aldrich and Sabrina Barton.
We'll
do that. Yeah. No, no. Yeah, I'll go.
Okay. You all review the instructions.
Yes.
Yeah.
Sure, you can come up. Who wants the defendant in here, please? Being Hayes, that's not. Let's see here. Monay Latrice Thomas, appearance for the record.
Jeff Reynolds on behalf of the people, Your Honor.
Assistant Public Defender on behalf of Monay Thomas.
Okay, it's the time for us to proceed on jury trial. The jury is present. Do we have any preliminary matters before we let the jury in?
Nothing from the people, Your Honor.
Your Honor, when did we talk about evidence and or proposed exhibits and objections there?
Well, if you needed to have some stipulations, you would do that now if you already have them ready. You should have had your exhibits marked, or you can get them marked as they're being admitted.
The original defense instructions included a text message that they wanted to admit as evidence. However, it is not time, date, and stamped. So we would object to the admission of that.
You said their original defense?
I'm sorry, the
exhibit?
original prosecutor's
Okay.
instructions indicated that they were going to utilize text messages. However, I did not see time, date, and stamps on the text messages to verify when they were sent.
So you're seeking to do a motion in limine while the jury's here?
Yes.
And you didn't think we should address this earlier before the jury got here?
I didn't know that we addressed trial matters before the trial started. I'm sorry.
Typically, you would file a motion in limine prior to the day of trial so they can respond, and it will be in
I
writing.
see.
Did you want to respond to the motion?
Yes, Your Honor, it was not my plan to introduce any text messages, so I believe that would not be an issue.
Okay, sounds good. Any other preliminary matters?
Nothing from the people, Your Honor.
Nothing for the defense. Your Honor.
Okay. All rise for the jury. Not to squeeze in, should have room for everyone. You can be seated. Text that issue. Okay, good morning, everyone. Let me get some people in the jury box. When I call your name, you'll start by filling in the inside. That way you gotta walk around to get there. You can't enter on that side. Okay, juror number 1 is gonna be Gary Millen. Juror number 2, Desiree Cook. Juror number 3, Jeanette Claudio. Juror number 4, Christopher Carlisle. Juror number 5, Carmeletta Smith. Juror number 6, Diana Natalansky.
Very good.
Oh, thank you. And then juror number 7, McKinley Dambro. Okay, so everyone, both in the jury box and in the gallery, you want to pay attention to the screen here. I have some instructions. Everyone can see? Okay. Okay, good morning again, ladies and gentlemen. I am Judge Kristen D. Simmons, and it is my pleasure and privilege to welcome you to the 54A District Court in Ingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of the free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and the prosecution has the right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. This only does this when I'm doing jury instructions and they're trying to figure out why. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on a jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask you to stand and swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honest. All rise. And raise your right hand. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? If you do so, say I do.
I do.
Thank you. You can be seated. like to introduce members of my court staff. First, I have my court recorder and my judicial assistant. That's Miss Addie Nash. She's sitting to my right. And then over here to my left is my court officer. That's Mr. Nicholas Bigelow. This is a criminal case involving the charge of assault or assault and battery, which I will explain more fully later. This charge has been made against the defendant. Her name is Monay Thomas. The defendant's attorney's name is John Lee. Mr. Lee, please stand and list any witnesses you anticipate calling in today's trial.
Thank you, Your Honor. Assistant Public Defender John Lee. I'll be calling Monay Thomas as a witness.
Thank you. And then the assistant prosecuting attorney in this matter is Jeffrey Brodowitz. Mr. Brodowitz, please stand and list any witnesses you anticipate calling in today's trial.
Thank you, Your Honor. My name is Jeff Brodowitz. As the judge said, I am the assistant prosecutor on this matter. The witnesses I intend to call today are Michaela Thomas and Juanetta Bush.
Okay. Does anyone in the jury box or anyone waiting for their chance to be in the jury box know the defendant or the lawyers or any of the witnesses that was just named? If you do, just raise your hand for now. Anybody know anybody? No one? Okay, very good. We think this trial will last for 1 day, meaning we should be able to complete this today. If you believe that the length of the trial will be a real hardship for you, please let me know now by raising your hand. Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have medical problems that make you unable to sit for 2 to 3 hours at a time? Or does anyone have a sight or hearing problem? First, taking the seating issue. I can't sit for 2 to 3 hours at a time, and I don't have a medical issue. But does anybody have an issue sitting for about an hour at a time? Ma'am, you do?
Yeah, I'm pregnant.
Okay, so you can't sit for longer than an hour. Okay. If you get in the seat there, then you'll just remind me, okay? Anybody else have an issue sitting for an hour at a time? Okay. And then hearing, can everybody hear me?
Yes.
Okay. You can't hear me, ma'am?
I got it all the way up.
It's all the way up and she still can't hear? I don't know.
I can hear, but not clear.
Not clearly? Well, we can switch that one. Let's try to switch it. Do you wear a hearing aid? Oh, she doesn't have it on.
I do, but I don't have it with me.
Okay. Does that work better?
I can't. I can hear you, but not in here.
Do you hear me better without that on? Can you hear me clearly? So it doesn't sound like that helps you.
No.
Okay, well then don't use that. If you can hear me with my voice like this, you should be fine because I'll require everybody to speak the same decibel, okay? As soon as you don't hear what I'm saying, you raise your hand immediately, okay? Okay, very good. Anybody have a sight problem? Everybody see us? Okay. Give me just a moment. Mr. Lee, who was representing Mr. Navari? Because he's in my waiting room. Mr. Lee, can you hear me?
Yes, ma'am.
Who's representing Mr. Navar? He's in my waiting room.
Not me.
Okay, Ms. Donnelly? We're gonna reset him. Give me just a moment. I apologize for this. Let's see. Ms. Donnelly?
Yes.
Thank you. What's your name, sir? Can you hear me?
Andrew Lamar.
Excuse
Yes, I
me?
can hear you, ma'am.
Okay, were you supposed to be here
Yes, I
at
can
10
hear
o'clock?
you. Yes, ma'am. I apologize for being late, ma'am. I just remembered and I freaked out and I called you. I apologize.
Okay, we're in the middle of a jury trial, so I'm gonna reset your matter. You need to call your attorney, okay?
Yes, ma'am. Thank you so much. I apologize.
August 28th at 10. Did you hear me?
No, ma'am, I did not hear you.
August 28th at 10 a.m. I might need you to appear in person because your volume is very low. I can barely hear you.
Yes, ma'am. All right, I'll be there. Thank you.
Thank you. Okay. Yeah, I apologize about that. Let's get back on this. Okay, so no health issues, no scene issues, just Zoom issues. Okay, this is a criminal case. The paper used to charge a defendant with the crime is called a complaint. The complaint in this case charges the defendant Monay as follows. On or about April 14th, 2020, at 3323 Independence Lane, City of Lansing, Ingham County, State of Michigan, the defendant did allegedly commit the act in count 1 of assault or assault and battery. That the defendant did make an assault or an assault and battery upon the following person, that being a Makia Thomas, and that this was done contrary to Michigan Compile Law 750.81. The defendant has pled not guilty to the charge. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal trial so that the defendant and the jury can hear the charges. You must not think that it is evidence of her guilt or that she must be guilty because she has been charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecution has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. We will now begin with voir dire. Prosecution, you can proceed.
Thank you, Your Honor. Morning again, everyone. My name is Jeff Barnes, I'm the assistant prosecutor here. As the judge stated, we're going to go through a process called voir dire, where myself and Mr. Lee, we're just going to ask you some questions. Not trying to embarrass anybody, not trying to pry into anybody's life. We're just trying to make sure we can get the most fair and impartial jury that we can for this matter. So just to start off, just some basic questions for everybody. Has anyone served on a jury before?
I don't serve, but I've done this before.
Okay,
But
you've
I
done.
actually-
Did you serve on the jury at all? Okay. Do you remember what type of case it was off? Criminal case, civil case?
I think it was civil, it was a mix, I don't know if it makes a difference, but some guy didn't get a raise and or something like that.
Okay. Yeah, that would be a civil. Does anyone know, the defense attorney, has anyone had any interaction with the public defender's office as a defendant before? Or a witness?
No.
Okay. Has anyone had any interaction with the prosecutor's office before as a witness, victim, defendant?
No.
Okay. So just one basic thing. So as the judge said, this involves the crime of assault or assault and battery. Now, has everyone heard of assault or assault and battery before?
Yes.
Okay. And has anyone here had a family member that's been a victim of an assault, a family member, close friend, anyone like that that's been a victim of an assaultive crime before?
No.
Yeah. And that would be Miss Claudio, family member, friend?
My daughter.
Okay. And she was the victim of an assault?
Yeah, but we never did.
Okay. Would that experience with your daughter being the victim of assault impact your ability to be fair and impartial here today? So now one of the elements that will need to be proved here was that there was a harmful or offensive touching that was against Miss Thomas's will. Now, who here believes that that harmful or offensive touching needs to be sort of person to person, like, skin to skin contact? Does anyone think that that's the only way that there could be an assault and battery?
You mean, are you talking about clothing?
No. So does anyone believe that there cannot be does anyone believe there can't be an instrument used in some shape or form? Okay. Now, you'll also hear, I anticipate you'll also hear evidence that in this crime, it involves two people who are related to each other. They're members of the same family. Does anyone here believe that matters that happen between members of the same family should be kept within the family and they shouldn't be brought to court like this?
No.
Now, one of the other elements we will need to prove is intent. Assault and battery is a general intent crime, which means that under the law that it's just essentially that it's not an accident. So as long as I can prove beyond a reasonable doubt that the actions taken were not an accident, would anyone here have a problem coming back with a verdict of guilty? And does everyone think they can, or does everyone understand and think they can, determine between what's an accident and what's an intentional act? Yes. Oh. And so just, Mr. Carlisle.
Yes, sir.
How would you, I guess, what type of evidence would you look for to determine someone's intent?
To determine someone's intent
Yes.
to commit harm on another person.
Yeah, like whether they meant to do the act they're committing. Like, I guess what I'm asking is, would you need to, hear them say something specifically, or would their actions be enough for you to judge their intent?
I believe the action would be pretty much sufficient.
Okay. And then Mr. Miller, same thing.
Yeah, their actions will supersede any sort of intentions.
Okay. Now, in this case, as you've heard from the judge, the alleged date of this is all the way back in 2020. So we're quite a few years beyond that. And I anticipate most of the evidence you'll hear today will be witness testimony. And so does everyone understand, is anyone here expecting some independent eyewitness to come forward and say, I know exactly what happened, I have a photographic memory, I saw it all? Is anyone expecting that?
No.
Is anyone expecting some sort of, high-tech scientific evidence that'll prove, 100% that this happened?
No.
Okay. And does everyone understand that, as I stated, this has happened 3 years ago, so people are going to have imperfect memories. They may not remember things exactly as they would have 3 years ago. Okay. And in regards to that, do you believe that you as the jury would be able to judge based on the testimony you hear today and any evidence you see, the credibility and believability of those witnesses? So as the judge also mentioned, I, as the prosecutor, need to prove this case beyond a reasonable doubt. So I just want to ask Ms. Smith, what does beyond a reasonable doubt mean to you?
That the facts are absolute.
So when you say they're absolute, would that mean it's, 100%, absolutely sure? If you had to put a percentage on it, what percentage would you put it?
At least 90% that it had to be.
Okay. And then Miss Cook, same question.
Reasonable?
Yes.
Oh, at least 80.
Okay. So just to put a little bit of an example out there. So let's say you wake up in the morning and you see that, you walk outside your front door and the grass is wet, the sidewalk's wet, your car windshield is wet. It would be safe to assume that it rained that night, correct? Okay. But would it also not be possible that overnight there was some guy standing on your roof with a hose spraying water all over your front yard and sidewalk and car? Is that also possible?
No.
It could be.
Okay.
There's like a 1% chance of
Okay.
it.
So you say there's a 1% chance. So would that be a reasonable assumption that there was somebody standing on your roof spraying water all over the place?
No, not reasonable.
Okay. So I just wanted to put that out there because that's the standard of proof that I have to meet here in this case. Is everyone okay with that standard? Okay.
Yeah.
And so then if I meet that standard, would anyone here have an issue coming back with a verdict of guilty?
No.
Okay. So one of the other issues that I think a lot of people come up with when they're sitting on a jury is they think of punishment. Ultimately, at the end of this case, if I prove my case beyond a reasonable doubt and you folks come back with a verdict of guilty, there will be a sentence rendered. However, that sentence is solely up to the judge's domain. Does anyone think or feel that they would take punishment into account when deciding on the verdict in this case? No other questions at this time, yeah?
Mr. Lee.
Good morning. Thank you all for being here. I know y'all took time off from work and made arrangements and got babysitters and those things. So thank you, honestly, for being here and participating. My name is John Lee. I'm the Assistant Public Defender with the Ingham County Public Defender's Office that will be trying the case today. My client is Miss Monay Thomas. She is the defendant, okay? And my first question to those of you who are paneled on the jury right now is, how many of you think Ms. Thomas must be guilty of something because she's sitting here in this chair right now? Something must have happened, right? I mean,
Something must have happened.
sorry?
Something must have happened.
Something must have happened, right? So there's a good reason why she's here, right? And then let me follow up with that. If there's a good reason why she's here, isn't she kind of guilty already?
Everyone make sure their cell phones and devices are off.
I don't know how to shut my phone off. Sorry. Sorry. Oh, I see it. Thank you.
Proceed.
So that kind of brings me to my next question, then, this question of reasonable doubt. What does that mean? Who can tell me what reasonable doubt really means?
It
Anybody?
really has to be, you gotta really think about it and make sure it is or isn't.
And so when we can't figure it out for sure, when we can't say for sure, what do we do?
Evidence.
It's juror number 3 speaking. I need you to identify on the record when they respond.
I'm sorry.
That's
juror
for
number
both.
three, Ms. Klein. Yes, so when we look at the evidence and the proofs and we listen to all the testimony and we try to figure out what is not sure. That's called a reasonable doubt. That's a non given. So just keep that in mind as we proceed. Ms. Claudio, you said your juror number 3, I'm sorry, you said your daughter was a victim of an assault and battery?
Yes.
Was it reported?
No.
No, okay. And juror number 4, Mr. Carlisle. Are you a bus driver? Yeah, okay. So you've probably seen a few school bus fights. Yeah. And have you ever been an intermediary or somebody who's tried to figure out what happened? How did it start? What's going on?
I leave that for security to take care of.
Okay.
Pretty much. Yeah. Things happen, I try to get away from it. Call the proper authority to handle it.
Call the proper authority. Yes, ma'am. Juror number 3.
I drive a school bus for deemed transportation, and I've had plenty of fights on my bus with children.
Okay.
And we have cameras, so I don't break it up because we are trained not to break them up.
Okay.
We don't want to encounter stuff like that, so we don't break it up. But when we get to the school, we call security comes.
And they review the video. There's no video evidence in this case. You have the two people are going to testify and tell you, one person's going to tell you one thing and another person's going to tell you another thing. You think you'll be able to kind of listen to the witness testimony and figure out what happened or make a decision one way or the other? Is there anybody who'd be uncomfortable with that? Is there anybody who needs more? All right, that's all my questions. Thanks, guys.
Mr. Bartlett, challenges for cause.
No challenges for cause, Your Honor.
Julie, are there any challenges for cause?
No challenges for cause, Your Honor.
Mr. Bartlett, any preemptory?
Your Honor. At this time, the people would like to thank and excuse juror number 3, Your Honor.
Thank you, Ms. Claudio. You may be excused. Mr. Lee, any preemptory? Okay, I'm gonna replace your number 3 with Richard Garcia. Okay, Mr. Garcia, we're gonna start with your voir dire, counsel.
Thank you, Your Honor. All right, Mr. Garcia. Good morning, sir. You heard all the questions that myself and Mr. Lee asked. Do you have any answers that you'd want to make us aware of?
I have been an assault. I did the charges. Friend, you know, not my friend. Going out.
You were the victim of the assault? Okay. And would that experience impact your ability to be fair and impartial here today?
It depends up here. My friends are not, you know, things happen.
Okay.
They're strangers, one thing, but they're like longtime friends.
Okay.
I'm sorry, you're saying that if they're friends, you can't be impartial?
Yeah, well, with my friend, I pressed charges up for assault. You know, they took pictures, that was it.
Okay, but the question is, can you be an impartial or fair juror? That's the question.
Well, me and him are still friends, you know. After this assault.
Okay, so I need you to answer the question though. What about being a juror? Can you listen to this case and be open-minded and fair? Or will you not be able to do that because of your prior history as a victim of assault?
Yes, I could do this.
I couldn't hear you?
Yes.
You could be fair? Okay, thank you.
Okay. And I see, I'll sheet here, you listed your employment as dispatcher. Do you work with law enforcement?
No, tow truck.
Okay. Tow truck. Okay. All right. No other questions at this time, Your Honor.
Mr. Lee?
Mr. Garcia, the two people in this case, the complaining witness and the defendant, are cousins. They're related. How does that make you feel?
No tells anything I went through, something that happened and over it. The other people, family, friends do. But me.
You feel like you would, at the outset of the case, have a feeling one way or the other about which way this case maybe should be going?
I don't know the details, but
Seem a little unsure. Do you sort of have a predisposition that you think?
well, I am so sure that I've solved it by now. The thing with me was before COVID. After we got here.
Could you speak up, please?
Yep.
Here's what I really want to know. When we start putting on the evidence and people start testifying and so forth, will you be able to listen to what they're saying fairly and objectively and consider all the things that are involved?
Yes.
And make a decision that's reasonable?
Yes.
Thank you.
Mr. Broderick, challenges for cause.
No challenges for cause, Your Honor.
Mr. Lee, any challenge for cause?
I'll challenge for cause, Your Honor.
Okay, Mr. Broderick, any preemptory?
People are satisfied with this hearing, Your Honor.
Thank you. Mr. Lee?
The defense would like to thank and excuse juror number 3, Mr. Richard Garcia. Your Honor.
Thank you, Mr. Garcia. You may be excused. We're going to replace juror number 3 with Catherine Toomey. Thank you. Okay, Mr. Broderick, you may want to Ms. Toomey.
Thank you, Your Honor. Good morning, Mr. So you've heard, if you could speak up just a little bit.
Yes.
Everything. So you've heard all the questions myself and Mr. Lee asked. Is there anything, any answers you feel we should be aware of?
I do have experience with a family member with an assault case, yes.
Okay, and was that family member victim of an assault?
Yes, my mother, she was a victim.
Okay, and was the The perpetrator of that assault, was that a family member, stranger?
It was her.
Okay. So it was more of a domestic violence situation? Okay. And would your experience with that situation, or with your experience with that situation, would you be able to be fair and impartial here today?
Yeah, it's so
Okay.
fair.
And again, I see on here, your occupation is behavioral technician. Can you, I guess, just explain a little more about that?
It's just basically working with children with autism,
Okay.
implementing ABA therapy.
Okay. No other questions at this time, Mary?
Mr. Lee?
Thank you. Ms. Toomey, you heard some of our previous discussions about reasonable doubt and so forth. How do you feel about reasonable doubt? What does that phrase mean to you?
I guess it's just like, I don't know, it's really hard to explain that, to be honest, but like my take on it would be just like, either there's no doubt about something or the doubt is very unreasonable. I don't know, like that's what I kind of took on it.
So a reasonable doubt would be a doubt that is legitimate. It's a reasonable doubt. I just don't know. Right?
Yeah.
Okay. It's a tough thing to put.
Yeah.
It is. I appreciate you trying to do. Okay, thanks. No more questions, Ron.
Thank you, Mr. Brodowitz. Challenges for cause.
No challenges for cause, Your Honor.
A lot of fun going on in the jury box today.
The defense has no challenges for cause.
Okay, any preemptory?
The people are satisfied with this jury, Your Honor.
Mr. Lee?
The defense is satisfied with this jury as well.
Okay, very good. So ladies and gentlemen of the jury, the 7 of you will be serving as jurors in this. The remaining of you all that were in the gallery, I do apologize that you didn't get to execute one of your most fundamental duties today, but there's still a chance tomorrow. So with that being stated, I will release the remaining of you off with our deputy court administrator. Thank you again for being willing to appear and serve here today. And hopefully you'll get an opportunity to do so tomorrow. All rise for the jury. Okay, you can be seated. Okay, so we're gonna go over some instructions and then I'm gonna release you for lunch. So let's see. Again, if you can fix your attention to the screen here. Ladies and gentlemen of the jury, you have been chosen to decide a criminal case made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Please rise. Raise your right hand. Okay, do each of you solemnly swear or affirm that you will, in the action now before the court, you will justly decide the questions submitted to you and that unless you are discharged by the court from further deliberation, you will render a true verdict and that you will render your verdict only on the evidence introduced and in accordance with the instruction of the court? If you do so, please say I do.
I do.
Thank you. You can be seated. You will have a written copy of my instructions that I'm going to read to you. You won't get them until at the conclusion of all the proofs at the time of deliberation, though. Since no one can predict the course of trial, these instructions may change at the end of trial. At the close of trial, I will provide you with a copy of my final instructions for you to use during your deliberations. Now I will explain some of the legal principles you will need to know and the procedure we will follow in this trial. First, the elements for use of assault. In this particular case, the defendant is charged with the crime of assault and battery. To prove this, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery upon a Makia Thomas. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Makia Thomas's will. It does not matter whether the touching caused an injury. Second, that the defendant intended either to commit a battery upon Makia Thomas or to make Makia Thomas reasonably fear an immediate battery. As used in these instructions, the word force and violence mean any use of physical force against another person as to harm or embarrass her. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about April 14, 2020 within the city of Lansing, Ingham County. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has proven every element, or if you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. The trial will follow this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes his, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the evidence. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer does not. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyers has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove her innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of any of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in the trial is to ensure that the trial is run fairly and efficiently, to make decisions about evidence and to instruct you about the law that applies in this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in the case is final. Part of your job in deciding what the facts of the case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on the witness's race, national origin or ethnicity, gender identity or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand facts in this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to my court officer who will give it to me. Do not show your question to other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand. That should say immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of this case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. You must not talk to the defendant, the lawyers, the witness, or anyone who may be connected to this case. This means that you may not speak to these individuals even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and you are not allowed to discuss the case. If they continue, leave. Report the incident to my court officer as soon as you return to court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth and lawyers must be able to cross-examine them. Because news reports do not meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider must meet certain standards. For example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you will see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated my instructions, report it to my court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see that we have chosen a jury of 7. After you have heard all of the evidence and my instructions, we will draw lots, that means drawing names, to decide which one of you will be dismissed to form a jury of 6. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After my final instructions, you will go to the jury room to decide your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not to make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. That concludes our jury instructions, just in time for noon. So I'm going to give you 30 minutes for lunch. There are some restaurants down on the main strip if you're not familiar with the downtown area. There's a jury room back here, which is where you will be when you return. You need to be back here by 12:30. Again, there is an instruction that you are not to speak to anyone because you may inadvertently speak to someone connected to this case. You do have your stickers that indicate that you are a juror. If someone attempts to speak to you about the case or in your presence, remember to tell them to stop. You report it to my court staff when you return. If you have any other questions or issues, you can speak with Mr. Bigelow here about that, okay? All rise for the jury. Sorry.
Thank you.
Okay, you can be seated. Do we have any issues you need to address before we break for lunch?
Just briefly, Your Honor, I was looking at the complaint here, and we were going through the jury instructions were correct. However, I believe on the complaint, the victim or complainant is listed as it looks like Michaela. Instead of being MA-KHIA, which it is, I believe is how it's correctly spelled, it's spelled MA-KHLA. So I'd just like to amend the complaint so the complaint reflects the victim or complainant's correct name.
Okay, so the complaint, any objection to amending the complaint to the proper spelling?
No objection.
Okay, I do see here, even on the complaint in this section, this is victim or complainant. I think it was spelled correctly there. It's just not in the body. It wasn't correct in the body. Is that accurate?
No, it's correct in the body of the complaint, but not where it's listed as victim or complainant or under witnesses.
Okay, is it Michaela or Makia?
I believe it's Makia.
Okay, so then.
So it was correct in the instruction.
It was correct in the instruction, which is where in the body of the complaint, at the top where they give the other information included under the witness section. That is the portion that needs to be amended, which is really not germane, but your motion is granted.
All right, thank you.
Any additional issues?
Not at this time, Your Honor.
For the detention.
Thank you. We'll see you at 12:30.
Thank you.